New State Ice Company versus Liebmann is a very fascinating case decided by the Supreme Court in 1932. The facts of the case are fairly straightforward. Mr. Liebmann was selling ice in blocks in Oklahoma City. He did not, as required by law, have a license to do this. But the New State Ice Company had a license obtained under a 1925 state statute. It naturally went to court and tried to stop Mr. Liebmann from opening a rival business. The question in the case is whether the Due Process Clause of the 14th Amendment permits Oklahoma to enact a state statute requiring a certificate of public interest and convenience, in other words, a license to sell blocks of ice. The holding of the case is that the Oklahoma statute violated something that was called substantive due process. The idea at the time was that the due process clauses, the Fifth Amendment, the 14th Amendment vis-a-vis the states, also protected certain private expectations, freedom of contract, liberties of an economic kind. Substantive due process most frequently acted as a check on various forms of state economic regulation, minimum wage requirements, maximum hour requirements, market controls and entry, anything of that sort. Unlike some decisions of that era, Justice Sutherland's opinion in this case is actually quite modest. The state can impose all kinds of regulations, health and safety regulations, purity regulations, and so forth, even on ordinary private businesses. A state may also require certain businesses to obtain a license, a certificate of public convenience and necessity. Those were usually industries that were natural monopolies or public utilities, something of the kind, or very peculiar professions, lawyers, doctors, and so forth. But those kinds of restrictions on market entry, the majority said, are unwarranted when you're dealing with an ordinary business. At some level, the dispute between the majority and the dissenters, you can understand it as simply a question of, look, how closely do we look at the rationales that the legislature has proffered? Justice Brandeis' dissent foreshadows what in later decades became as a rational basis test of review. That is to say, so long as the legislature gives us some reason, any reason almost, and so long as it's economic legislation, we'll let it pass. One of the great advantages of our federalism, Justice Brandeis famously wrote, is that states can serve as laboratories of democracy and experiment with various forms of regulation. New State Ice versus Liebmann was one of the last substantive due process decisions. It has never been formally overruled, but it has been abrogated and superseded. And that happened very, very fast. What the two opinions, the majority opinion and Justice Brandeis' dissent, bring into sharp focus and what is worth thinking about are two subjects. One is the nature and scope of economic liberty, let's call it that. To what extent does the United States Constitution protect those kinds of liberties, and how? And that is a very live question, and that question overlaps with the federalism angle that is emphasized in Justice Brandeis' dissent. To what extent do you want states to let experiment with particular forms of regulation?